More than 100 years ago, in what was then the New Beacon Religious Education Program, Ellen Lyman Cabot wrote this: "We sometimes speak as if the past were over and done with. That's past, that's out of date, that's ended. Yet try to obliterate it in your thought, all that is in the past. It's impossible, of course, because in doing so, we obliterate ourselves. Without the help of what we call the past, we could not live at all. The past, instead of being done with, is then the real fiber of the world as we know it. Just as the food we eat nourishes us till it becomes what we act with, the past is always what we think with." My intent today was to recognize the 100th anniversary of the 19th Amendment that granted women the right to vote, and to celebrate some of the notable UU women who fought for that right. And true to form in the past week, our soon-to-be former president made news this week by granting Susan B. Anthony something she never wanted: a pardon for the crime of voting. Susan B. Anthony herself was raised in a Quaker family that eventually attended the First Unitarian Church of Rochester, New York. She continued to attend Unitarian churches most of her life and expressed views that we would call agnostic. Anthony is clearly a Unitarian hero of the women's suffrage movement, and she credited the famous Unitarian feminist and women's rights advocate Margaret Fuller as being a model and inspiration for her. In History of Women's Suffrage, Anthony wrote this: Anthony wrote that Fuller possessed more influence on the thought of American women than any woman previous to her time. That's quite a statement coming from Susan B. Anthony herself. But why were women denied the right to vote in the first place? Because men are often weak, often stupid, and scared to let women have any type of voice or leadership role. Much, much more true in the past than it is today, and we are getting better. Simply, men blamed science at the time. There's a recent story that maybe some of you have seen on the internet about an evangelical conservative pastor bemoaning and criticizing veganism. He believes that veganism is an evil plot to change the DNA of humanity. He says that if people become vegans and stop eating meat, that their DNA will change, that they won't actually be human at all, and then they won't be able to be saved, which of course is what he believes he is called to do as a pastor, not using science in the right way. In the same way, men used to claim that women were physically and mentally not able to vote. They didn't have the intellectual capacity, and physically that it would alter their DNA, making them unable to bear children. It would affect their womb, and they were not able to vote, they were not able to own property, and they were not able to become lawyers and many, many other things. Susan B. Anthony, of course, saw all of the legal disabilities faced by women that started from the existence of this country. And she believed that all of these disabilities, all of the problems that women had were due to the lack of the vote. When Anthony, at age 32, attended her first women's rights convention in Syracuse in 1852, she declared that that right which women need above every other, the one indeed which would secure to her all other rights, was the right of suffrage. So I'd like to focus today on Susan B. Anthony's arrest and trial because I think there's a lot to learn from it. It offers some significant insight, and I think it offers some reasons that the soon-to-be former president wanted to grant her a pardon this week, thinking it was going to make him look good. Well, Susan B. Anthony had taken the position and argued it whenever she could that the recently adopted 14th Amendment gave women the constitutional right to vote in the federal election. The 14th Amendment said that all persons born and naturalized in the United States are citizens of the United States. And as citizens, they were entitled to the privileges of citizenship in the United States. To Anthony's way of thinking, those privileges had to include the right to vote. Keep in mind that the 14th Amendment was passed after the end of slavery and was intended to grant citizenship to the then freed slaves or former slaves of America. On November 1st, 1872, Anthony and her three sisters entered a voter registration office set up in a barber shop. The four Anthony women were part of a group of 50 women Anthony had organized to register in her hometown of Rochester. As they entered the barber shop, the women saw stationed in the office 3 young men serving as registrars. Anthony walked directly to the election inspectors and, as one of the inspectors would later testify, demanded that we register them as voters. The election inspectors refused Anthony's request, but she persisted, quoting the 14th Amendment citizenship provision and the article from the New York Constitution pertaining to voting, which contained no sex qualification. It did not specify men only could vote, and it did not say that women were not allowed to vote. Well, the registrars at the moment remained unmoved. Finally, according to one published account, Anthony gave the men an argument that she thought might catch their attention. "If you refuse us our right as citizens, I will bring charges against you in criminal court, and I will sue each of you personally for large exemplary damages." She added, "And I know I can win. There is any amount of money to back me, and if I have to, I will push it to the last-ditch effort." Well, the stunned inspectors discussed the situation. They were afraid that they would be breaking the law if they registered the women, but not being constitutional experts, they were also afraid they might be breaking the law if they did register the women. So do they or don't they? They were afraid that they could be breaking the law either way. They felt stuck. An hour or so of debate followed, and finally the men agreed to allow the women to register to vote. In all, 14 Rochester women successfully registered to vote on that day, leading to calls in one city paper for the arrest of the voting inspectors who complied with the women's demand. The Rochester Union and Advertiser editorialized in its November 4th edition, "Citizenship no more carries the right to vote than it carries the power to fly to the moon. If these women in the 8th Ward offer to vote, they should be challenged, and if they take the oaths and the inspectors receive and deposit their ballots, they should be all prosecuted to the fullest extent of the law." Soon after the polls opened on the West End News Depot on Election Day, November 5th, Anthony and 7 or 8 other women cast their ballots. Inspectors voted 2-1 to accept Anthony's vote, and her folded ballot was deposited in a ballot box by one of the inspectors. A couple of days later, after more debate, a deputy came to arrest her, and he came to her home and sat down at her invitation. He hemmed and hawed and finally said that the local commissioner wanted to see her. "Well, whatever for?" Anthony asked. "To arrest you," was his reply. "Is this the way you arrest a man?" "Well, no, ma'am." "Then," she said, "I demand that I should be arrested properly." The deputy then put handcuffs on her and walked her down to the commissioner's office. Upon arriving at the commissioner's office, Anthony was surprised to learn that among those arrested for the activities on November 5th was not only her, but also 14 other women who voted and the ballot inspectors who allowed them to vote. Anthony saw the commissioner's decision as a ticket to the Supreme Court review and began making plans with her lawyers to file a petition for a writ of habeas corpus. Anthony had 2 attorneys working for her. They didn't always talk to each other. They asked a U.S. district judge to order her release from the marshal's custody. The judge refused, but said he would allow the defendant to go to the Supreme Court of the United States. The judge then raised Anthony's bail from $500 to $1,000, ostensibly to keep her in jail so that she could go to the Supreme Court. Anthony, of course, refused to pay a dime. She was convinced she had committed no crime. One of her attorneys, though, hated to see her in jail and decided to pay Anthony's bail with his own money. In the hallway after the bail hearing, Anthony's other lawyer pointed out to her that the decision to pay her bail and release her from jail eliminated any chance she had to go before the Supreme Court. Well, going into the June trial, Anthony and her lawyers are somewhat less optimistic about the outcome that they had been a few months before. A special concern to Anthony was the court's decision that narrowly interpreted the 14th Amendment's Equal Protection Clause and upheld another state law that prohibited women from becoming lawyers. On June 17, 1873, Anthony, wearing a new bonnet, faced with a proper veil, silk and draped, she walked up the steps of the Canandaigua Courthouse in New York on the opening day. The second floor courtroom was filled to capacity. The spectators included a former president, Millard Fillmore, who had traveled from Buffalo, where he was practicing law at the time. The judge, named Ward Hunt, sat behind the bench, looking stolid in his black broadcloth and neck wound in a white neckcloth. Anthony later described him as a small-brained, pale-faced, prim-looking man enveloped in a faultless black suit and a snowy white tie. The main factual argument that the defense hoped to present was that Anthony reasonably believed that she was entitled to vote and therefore could not be guilty of the crime of knowingly casting an illegal vote. Anthony was called as a witness in her own defense, but the defense attorney, or the district attorney, objected, saying that she is not a competent witness on her own behalf because she is a woman. The judge agreed and barred Anthony from taking the stand. In her defense attorney's 3-hour presentation, they stressed that the vote was essential to women receiving fair treatment from legislatures. Much has been done, they said, but much more remains to be done by women. If they had possessed the elective franchise, the reforms to which they have been entitled for a quarter of a century would have been accomplished in a year. Central to the lawyer's argument that Anthony cast a legal vote was the recently enacted 14th Amendment. They insisted that even if the 14th Amendment did not make Anthony's vote legal, she could not be prosecuted because she acted in good faith because she believed that her vote was legal. This was core to the argument. After the district attorney offered his 2-hour response to the prosecution, the judge drew from his pocket a paper that had been previously written and read an opinion that he obviously prepared before the trial even started. The judge declared that the 14th Amendment gives no right for women to vote, and the voting by Miss Anthony was in violation of the law. The judge rejected Anthony's argument that her good faith precluded a finding that she knowingly cast an illegal vote. Assuming that Miss Anthony believed she had a right to vote, that fact constitutes no defense if in truth she had not the right, said the judge. She voluntarily gave a vote which was illegal and thus is subject to the penalty of law. The judge then surprised Anthony and her attorneys by directing the jury to return a verdict of guilty immediately, saying, "Upon this evidence, I suppose there is no question for the jury, and that the jury should be directed to find a verdict of guilty immediately." In her diary that night, Anthony would angrily describe the trial as the greatest judicial outrage history has ever recorded. In fact, the local newspaper quoted one juror as saying, "Could I have spoken, I should have answered not guilty, and the other men in the jury box would have sustained me." The next day, Anthony's lawyers argued for a new trial on grounds that Anthony's constitutional right to a trial by a jury had been violated. The judge, of course, promptly denied the motion. Then, before sentencing, the judge asked, "Has the prisoner anything to say why sentence should not be pronounced?" The exchange that followed stunned the crowd and the Canandaigua courthouse. "Yes, Your Honor, I have many things to say. For your ordered verdict of guilty, you have trampled underfoot every vital principle of our government. My natural rights, my civil rights, my political rights, my judicial rights are all alike ignored. Robbed of the fundamental privilege of citizenship, I am degraded from the status of citizen to that of a subject, and not only by myself individually, but also all of my sex. All are, by your Honor's verdict, doomed to political subjection under this so-called form of government. Judge Hunt then interrupted. The court cannot listen to a rehearsal of arguments of the prisoner's counsel that has already been made in 3 hours in presenting. But Anthony would not be deterred. She continued, may it please your honor, I am not arguing the question, but simply stating the reasons why sentence cannot, in justice, be pronounced against me. Your denial of my citizens' right to vote is the denial of my right of consent as one of the governed, the denial of my right of representation as one of the taxed, the denial of my right to a trial by jury of my peers of an offender against the law, therefore the denial of my sacred rights of life, liberty, property, and the judge interrupted her again. The court cannot allow the prisoner to go on, but your honor will not deny me this one and only poor privilege of protest against this high-handed outrage upon my citizens' rights. May it please the court to remember that since the day of my arrest in November, this is the first time that either myself or any other person of my disenfranchised class has been allowed a word of defense before judge or jury, or the prisoner must sit down. The court cannot allow it, the judge interrupted for a third time. Undeterred, she continued. All of my prosecutors, from the 8th Ward corner grocery store politician who entered the complaint to the United States Marshal, Commissioner, District Attorney, District Judge, your honor on the bench, not one is my peer, but each and all are my political sovereigns. And had your honor submitted my case to the jury, as was clearly your duty, she said, even then I should have had just cause of protest, for not one of those men was my peer, but native or foreign-born, white or black, rich or poor, educated or ignorant, awake or asleep, sober or drunk, each and every man of them was my political superior, hence, in no sense, my peer. Again, the judge interrupted. The court must insist the prisoner had been tried according to the established forms of law. Yes, your honor, she says, but the forms of law all made by men, interpreted by men, administered by men, in favor of men and against women, and hence your honor's ordered verdict of guilty against a United States citizen for the exercise of the citizen's right to vote, simply because that citizen was a woman and not a man. The court orders the prisoner to sit down, bellowed the judge. I will not allow another word. Again, undeterred, Anthony continues. When I was brought before your honor for trial, I hoped for a broad and liberal interpretation of the Constitution and its recent amendments that should declare equality of rights, the national guarantee to all persons born or naturalized in the United States. But failing to get this justice, failing even to get a trial by jury, not of my peers, I ask not leniency at your hand, but rather the full rigors of the law. Finally, Anthony sat down, only to be immediately ordered to rise by the judge again. He pronounced her sentence. The sentence of the court is that you pay a fine of $100 and the cost of prosecution. Anthony protested, may it please your honor, I shall never pay a dollar of your unjust penalty. All the stock and trade I possess is a $10,000 debt incurred by the publishing of my paper, The Revolution, 4 years ago, the sole object of which was to educate all women to do precisely as I have done. To rebel against your man-made, unjust, unconstitutional forms of law, the tax, fine, imprisonment, and hanging of women while they deny them the right of representation in the government, and I shall work on with might and main to pay every dollar of that honest debt, but not a penny shall go to this unjust claim. And I shall earnestly and persistently continue to urge all women to the practical recognition of the old revolutionary maxim, resistance to tyranny is obedience to God. True to her word, Anthony never paid a penny of her fine. Her petition to Congress to remit the fine was never acted upon, and no serious effort was ever made by the government to collect. Susan B. Anthony tried to turn her trial and conviction into political gains for the women's suffrage movement. She ordered 3,000 copies of the trial proceedings printed and distributed them to politicians, to activists, and to libraries. It took almost 50 years after the trial for American women to gain the right to vote in the Constitution. Deborah Hughes, the executive director of today's Susan B. Anthony Museum, said Anthony called her trial for voting the greatest outrage history had ever witnessed. She was not allowed to speak in her own defense because she was a woman. The judge in her trial also dismissed the jury and pronounced her guilty himself. She was outraged by the denial to trial by jury. Anthony proclaimed, "I shall never pay $1 of your unjust penalty." To pay would have been to violate or to validate the proceedings. President Trump's pardon of Susan B. Anthony does the same. The museum said the best way to honor Anthony and the other suffragists is to ensure that every person in the United States has access to a ballot box, and that is so significant this year. If one wants to honor Susan B. Anthony today, a clear stance against any form of voter suppression would be welcome, the museum director said. An act of voting is one that people have died to protect. Voting is not just a civil responsibility, but an expression of our dignity and evidence to what we do matters in this world. We vote not merely to win an election, but we vote for what is yet possible. This past week, Florida citizens voted in the state's primary on the same day that was the 100th anniversary of the ratification of the 19th Amendment, giving women the right to vote. Voting is a sacred and holy right by which we choose people to represent us and our values, to enact laws that bring us closer to the social justice that we as Unitarian Universalists want for every single person. This sermon is so much more than a simple history lesson. It's a reminder that Unitarian Universalists, it is in our DNA, not only to fight for our rights, but to also to fight for the rights of any marginalized people. Voting is one of the most important ways to do that. We owe much to Margaret Fuller and to Susan B. Anthony, and to the many women who demanded equal treatment under the law. Let's continue to honor the sacrifices they made by encouraging everyone we can to vote this November. It is our sacred and holy duty. Amen and blessed be.